Andariki Shubhodayam. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. We are dealing with a typical situation case. This is a case relating to the so-called advertisement given for the recruitment of junior civil judge come magistrates in Haryana state or Punjab state, where clause number 33 says no revaluation. Can judge uphold the no revaluation principle or not? Can judge prohibit revaluation of the answer sheet or not? This is the question. It's a very typical question. It's not that easy to answer, but agreed because of the clause number 33. How? We are going to discuss now. In the case of Dixa, kalon, she is a lady, versus State of Haryana and others, CWP number 4917 by 2025, decided on last day of February, that is 28/2/2025, by Chief Justice Shil Nagu and Sumit Goyal of Punjab and Haryana High Court, located at Chandigarh. They refused to interfere with the clause number 33 in the advertisement given for the recruitment of Haryana civil judge posts, in which it is clearly held that no revaluation or revaluation is prohibited. So in that case, when the board once again says that revaluation is not there, it is not violating any fundamental rights, any constitutional rights of the candidates. Of course, there is another leverage, that the so-called rechecking allowed. If you pay some 200 rupees or so, rechecking allotment of marks can be seen. But revaluation is not there, because the papers are being examined or being corrected by the experts, not ordinary people. You can't find fault with them. But whether it violates the natural principles, whether it violates the fundamental principles or not, we have to think over. It's not that easy. Simply by putting a clause or caveat, you cannot escape. But here the court said no. Coming to the facts of the case, let us discuss the facts of the case. On 7/11/2023, the Public Service Commission of Haryana Public Service Commission, they gave an advertisement for the post of civil judge. So every year we will be getting so many posts. Even in Indira Pradesh Law College also, our principals are trying to GCC aspirants. Haryana State Public Service Commission, they have announced vacancies on 7/11/2023, and this woman, Dixa Kalon, she applied for the post from the SC category. Right. On 16/10/2024, please remember, almost after 11 months, the final results were announced, and she received 493.10 marks, whereas the cutoff is 495. Finished. Now she can't appear. She is not selected, simply to say. Then she has approached the court. First, she approached the RTI, Right Information Act. Basing on that, she got the mark sheet, copy of the answer sheet through RTI. And she says, according to her, in English, one of the questions, she has written the correct answer, but it was incorrectly valued and 0 marks were put to her. She deplored that evaluation was not done correctly. But examiner says answer is not correct, because her language, the tenor used by her, is not understandable, and secondly, as per the opinion of the examiner, it's not correct. Right. Now she asked for revaluation, but clause number 33 of the advertisement very clearly says that rechecking allowed, revaluation not allowed. Reason is that they are getting the papers evaluated by experts. The person who examines, the person who awards marks, they are all experts. You can only recheck it, you can only recount it, but you cannot revaluate it. Otherwise, everybody will ask for the revaluation. There is a problem. The answer is evaluated by an expert. He said 0. That man is an ordinary man? No, he is a qualified person. So please remember, whether the provision that no revaluation will whether they infringe the legal rights of any person. No. Basing on the very famous case law. Dr. within brackets Major Meeta Sahai అనుకుంటా. Dr. Major Meeta Sahai versus State of Bihar 2019, because the examiner himself is an expert. So it is not correct to say that you have to go for revaluation. So WP is dismissed. Anyway, court said like this, but we have to think over the matter. Don't think that all examiners are that very, very experts. We have seen such persons also. But anyway, court said like this, better you hear it. We don't want any my own comments are not necessary. Thank you.